Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, February 28th, 2025. We're on voting list number 6. We're going to start off with House Bill 380, and that is Jamie.
House Bill 380 deals with...
Actually, Jamie, I'm sorry. My apologies. We all know what this bill does. There's a motion for an unfavorable.
Second.
Is everyone okay being recorded in the affirmative on the unfavorable?
Yes.
All right. We have disposed of House Bill 380 unanimously. All right. We'll now move on to Senate Bill 7.
Senate Bill 7 requires the Department of Transportation, in consultation with stakeholders, to develop or identify and implement a training program that includes a curriculum on the identification and reporting of suspected human trafficking. The department must administer the program to specified employees, including contractors. Each employee or contractor must certify to the department that its employees have completed the training program by January 1st annually, beginning in 2026. They must provide the training to new employees within 90 days after hire. They have to establish a human trafficking reporting procedure and implement a human trafficking prevention policy. And finally, the department must, to the extent practicable, require frequent public service announcements with safety information on human trafficking as specified in the bill.
All right. There's a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 7 passes unanimously.
Senate Bill 7.
Sorry. Geez. Senate Bill 7. All right. We'll now move on to Senate Bill 110.
Senate Bill 110 prioritizes the payment of unpaid child support over certain other claims on an estate of a decedent with insufficient assets to pay all the claims in full, putting it just after family allowances and just above taxes due by the decedent. This matches federal bankruptcy law.
This motion is for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 110 passes unanimously. We'll now move on to Senate Bill 118.
Senate Bill 118 repeals the provision that sets the maximum amount of $40 for a civil penalty imposed on an owner or driver of a motor vehicle that's recorded speeding by a speed monitoring system. Instead, the bill establishes an escalating penalty structure that ranges from $40 to $350, depending on by how many miles per hour the vehicle exceeds the speed limit. Just for context, that schedule matches what was part of the work zone camera bill, which was enacted last year. There is an amendment in your packet. It's number 143922/1. So the amendment does a few things. First of all, it adds to the bill an amendment to the provision authorizing the State Highway Administration or local jurisdictions to establish school zones in which they are authorized to place speed monitoring systems. So the current law is that a school zone may be anywhere within a half-mile radius of a school. With the amendment, that is generally reduced to 1/3 of a mile. However, if the administration or local jurisdiction makes a written finding that doing so is necessary for the safety of students, they can extend to that original half-mile radius. The amendment also changes the penalty structure to say that instead of saying that the penalties are the following amounts, they may not exceed the following amounts. That gives local jurisdictions some discretion to go under those numbers. And finally, there is part of the amendment which is somewhat technical and complicated, but essentially because there is another bill in the committee, Senate Bill 485, which institutes a similar but different penalty structure for violations recorded on Route 210 in Prince George's County. Because both of these bills amend the same provision of law in slightly different ways, there needs to be a contingency drafted into the bill to account for the possibility that both bills are enacted or the possibility that one bill or the other is enacted. So it looks a little bit complicated on the reprint, but the upshot of those amendments is that if both of these bills are enacted, sort of a merged provision which accounts for both the statewide and the 210 specific penalties goes into effect. But if one bill or the other is enacted and the other one is not, then basically just the one bill that's enacted goes into effect in that provision of law.
Senator 18. Did you call? Oh, sorry. Thank you. So, Council, I just want to be sure that, so I know you said the fee schedule goes consistent with what we did on last year's work zone, but we had two tiered systems. One was when workers were present, one was when they were not. So is this one, for these speed zones, is this the one that's when the workers were not present?
We're not present.
Okay, and then I guess my next question is if we're talking about school zone and school zone safety, are we still leaving those as not consistent with when like workers are present? Because I know some school zones do like increased fines double when children are present between the
Yeah,
hours.
so I believe the statutory authorization that fines may be doubled in the school zone while school is during school hours.
So by voting, so on this, voting for this, I want to be clear. So by voting for this, if statutorily, if the local jurisdiction chooses to put that banner above it that says fines double while children are present, even though it may be outwards up to a half mile again, it could be up to a $700 fine?
Correct, and just to be clear, there would have to be a written finding that going beyond that 1/3 of a mile is necessary for the safety of students.
But who was the one that makes that determination?
It would be the State Highway Administration if it's on a state road or the local jurisdiction.
Okay, just making clear that everybody's aware that we're now putting speed cameras again, and we're giving the authority to be able to, we did it for work zone safety because of the safety issue. But this is a whole new change. This is a whole new attempt to grab money, and I want to be very aware of that. We're already hitting our taxpayers with a lot of fee increases, so thank you, Mr. Chair.
This is only automated. This isn't for police stops.
Well, I think that is exactly my question, yes. Yep. So the fines may double when children are present. Does that apply only to when you are stopped by a police officer, or both a police officer stop and automated enforcement?
Only when you're actually stopped. The automated enforcement continues to have a cap on the penalty. That does not double.
Okay.
Where's that cap on?
Well, it does depend on whether the bill is passed. With the bill, it would be the sliding scale of penalties. Currently, it's $40.
And then, Mr. Chair, I have another question, but I'll yield to the Vice Chair.
I think there's a little confusion, and I just want to clarify on camera for the record. The fines in this bill only apply to automated speed camera systems. They do not apply to being stopped by police. The automated speed cameras in school zones operate only during school hours, even though you may see that they flash after school hours, which that's done in a strange way in order to dissuade people from speeding, but people don't get a ticket if they're after school hours. The fines doubling, a sign that you see sometimes, is not applicable for the automated speed system. These fines are only for automated. And so these fines will not double when children are present at all, because the doubling only applies when an officer stops you. And so I just want to be very clear for our viewers back home.
Thank you. First of all, let me just preface what I'm going to say by saying this. I do disagree with my cousin over here that
What?
It's either money grabbing or it's obey the law, and we can't say it's money grabbing over here when people are breaking the law. Either we agree that breaking the law requires that something is done, especially when lives are being taken. I'm 66 in the last 10 years. That's a lot. And I want to just ask a technical question. If our bills, if it only it crosses, it merges with 210 in a sense. Why can't we amend the 210 provision out of that bill and leave the bill? And then my bill would take care of 210.
That's what we're doing, that's what the amendment does.
So it takes two, because what we just had a big discussion about both bills and the $700, et cetera. So why are we having that discussion?
Well, the way it's drafted right now is either bill could pass and we're going to be fine. But that's why the amendment, that's why he explained the kind of walk through the amendment that if this bill passes and then yours doesn't, this new structure will go statewide and be fine. If your bill passes and this doesn't, it's still going to be fine. Like, it'll just apply to 210, your bill.
Right.
So I think it's going to be fine. I think we can still have these conversations separate. Sorry, we're going to get to Senator James, and then we'll go back to Senator Lowe.
Thank you. I think I was out sick when we had a bill hearing on this. So I'm looking at tentative testimony, you know, like MDOT and MACO say might, could, research shows sometimes. So I'm trying to understand, I'm all against, you know, speeders, especially excessive speeders, but I don't know if there's any data on how effective the cameras are now with their penalties, any evidence that increasing the penalties, doubling them, is going to bring about a behavioral change. I mean, I guess you could say intuitively you might think that, but given what I've heard lately, I don't think it does. So that's my issue. I'm all about helping to reduce speeds that are reckless, but I'm not seeing anything in the file anyway that suggests that this bill will actually bring down speeders. It will certainly raise revenue, and I'm not trying to be cynical about that, but I just don't know if it's going to change behavior. So is there some nationwide or other states that have data or maybe, or something that shows at what price the penalty has to be to bring down a behavior, and is it in this bill, or does that increase actually bring about reduced speeds? Thank you.
Could we add in the thing?
I was just about to say, we had testimony from Baltimore City.
He's going to answer. He's trying to.
We had testimony from Baltimore City about the reduction of the speeding because of the cameras that they had put on I-83, and I believe they talked specifically about your. They spoke to that point about the effect of people, and I even remember talking with my colleague right here, which and again, given the data, whereas he was at once opposed to speed cameras, he's now actually introduced a bill on behalf of the Baltimore County delegation because, in fact, it does change behavior. Revenue does become a part of it, but as Senator Muse said, if you obey the law, you don't have to worry about the state being in your pocket.
Well, I appreciate that. So I would just like that data, and as you know, I appreciate oral testimony, and even if it was written, I think obviously if they said that, they must be tracking it and reporting on it. So, and I think I would like more than just Baltimore City, but that would be a start. Okay, so hopefully we can get that data. Thank you. Otherwise,
It's a
speculative leverage.
Thank you, Mr. Chair. I just wanted to go back to a clarification on the amendment that voting on Senate Bill 118 is just the statewide, and we have the rest in just in case the other bill passes, correct?
That's correct. So,
Perfect, thank you.
right, yeah.
We can hold, yeah, we can fine, we'll hold it. To follow up with Senator James's inquiry, and then I want to make sure Senator Fulton gets a chance to speak, but we're going to hold it.
Yeah, that's fine.
Yeah, go ahead.
A perfect.
Yeah, absolutely.
For that. So is there in that discussion and in that same vein of thought, is there consideration or would there be consideration for, because we are enhancing the penalties, that we would have MDOT or SHA or whoever it is to report back the numbers, but then also if it actually showed a reduction in crashes in those areas, because this is what the point is supposed to be, in high conflict areas, that they report back annually or biannually or however often that, hey, we issued this many citations and we've seen this is how many crashes we had before we put them in and this is how many we've had since. I mean,
I think it's definitely, that's reasonable. Look, so if you look at AAA's testimony, they cite the number of crashes related to speed, but they don't, so that analysis can be done.
Yeah, so if we can add that in to show that they'll report back to us like annually with that?
That's fine.
Thank you.
And that's good.
Thank you.
That'll make it a better bill. Okay, we'll hold it. It's fine. All right, I want to make sure we get to, if we could get to 618, sorry, Josh. 618, it's on the second to last page.
Senate Bill 16 requires, 618, requires an initial and renewal application for a driver's license, identification card, or moped operator's permit to allow the applicant to choose to indicate on the document that the applicant has a non-apparent disability. There are two amendments in your packet. The first is number 403828/1. This just amends the short title to add Eric's ID law. And the other amendment is number 263325/1. The amendment does a couple things. First of all, it adds a requirement for the Motor Vehicle Administration to delete any records about the non-apparent disability notification on request of the applicant. And it also modifies the restrictions that the MVA has on disclosing any records relating to the notation, and generally provides that the MVA may not disclose any of that information without a court order, except that it is allowed to disclose the information to a court, a criminal justice agency, a licensing authority, the applicant, or the Child Support Administration. Yes, the MVA had a chance to take a look at these amendments, and they are okay with them.
The amendment's been adopted. Now the bill's before he's amended. There's an amendment. Senator Jackson would like to be added on as a sponsor. Senator Charles, Senator McKay, Senator Love, Senator West, Senator Sidnor, Senator Wallstreicher.
Is anybody not on this?
Senator James wants to be on. Senator Muse wants to be on.
Everybody?
Senator, of course.
This is voluntary, correct?
Correct. Senator
Everybody's
Fulton.
on it.
All right, committee's on.
And Jackson?
All right, so, and Jackson wants to be on as well. So is that okay? Move favorable on the sponsor amendment? Okay, so every member of the committee is now on the bill, plus Senator Jackson. Motion is for favorable with amendments. Seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 618 passes with amendments unanimously. There you go. Excellent. All right, we'll now move on to, make sure, let's get to, this one's pretty, so we're gonna go right back into order. Senator 126.
Senate Bill 126 authorizes a trustee of a trust under the Maryland Trust Act to resign without having to seek court approval, provided that at least 30-day notice is given to the qualified beneficiaries of the trust, the settlor of the trust if they're still alive, all co-trustees, and any person that has the right to replace or appoint a successor to the resigning trustee. This still leaves in place the current process where they go to the court seeking approval.
All right, so motion for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill
126, we're back on the first page.
Is that okay? Is everyone okay being recorded in the affirmative? Okay, Senate Bill 126 passes unanimously. Keep going. Just a Senate Bill 135.
Senate Bill 135 establishes that unless waived by the client, a communication between an attorney and a client that is acting as a fiduciary separate to this attorney-client relationship is subject to the attorney-client privilege, even if fiduciary funds are used to compensate the attorney for legal services given to the client. The existence of a fiduciary relationship between a fiduciary and a beneficiary does not constitute or give rise to a waiver of the attorney-client privilege for communications between the attorney and the fiduciary. Under the bill, fiduciary includes a person granted authority to act for a principal under a power of attorney.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 135 passes unanimously. All right, we're gonna, that's withdrawn. Oh, I don't want to make sure. Okay. Make sure I do this. All right, can we go down to, this is on the, it's Josh, Senate Bill 811.
Senate Bill 811 extends the termination date for the task force on the creation of a division of returning citizens and expanded reentry services from June 30th, 2026 to June 30th, 2027, and additionally extends the deadline for the submission of their required reports. This was mentioned at the hearing. In the bill as drafted, the extension for the report is from December 31, 2025 to October 31, 2026. I believe it was mentioned that it might make more sense to make the extension to December 2026. Yeah.
All right, so you adopt the amendment?
Yes.
Okay. Is everyone okay? Okay.
I need 1 second.
Yeah, 1 second. Sorry.
Okay.
Let me know when you're ready. Okay, take your time. Okay, so now the bill is before you as amended. The motion is for favorable. Second. Is everyone okay being recorded in the affirmative? All right. Sure. All right. Yes. Senator West would like to be a co-sponsor. 811. It's on the last page. Superstar. Let me know when you're ready. So Wes, yeah, I'll jump on. Fine. Yeah. Yeah.
Okay.
Okay, now the bill's before you as amended. Motions for favorable with amendments. Seconded. Is everyone okay with being recorded in the affirmative? Okay. Senate Bill 811 passes unanimously with the amendment.
Yeah.
Senate Bill 274, that's Senator Love.
Senate Bill 274 alters statutory provisions that authorize, in certain cases, a court to order the testimony of a child abuse victim to be taken outside the courtroom and shown to the courtroom by closed-circuit television. Specifically, the bill repeals a requirement for the court in regard to a determination that testifying in the presence of the defendant or child respondent will result in the child victim suffering serious emotional distress, to find that the child will be unable to reasonably communicate. Instead, the court would find that the child would suffer serious emotional distress. There is one amendment in your voting packet. The amendment provides that if the child victim testifies by closed-circuit television, the testimony shall be given within the courthouse in a setting that the court finds will reasonably mitigate the likelihood that the child victim will suffer emotional distress. And if you turn to the last page of the reprint, you'll see new language that provides that the defendant or child respondent shall have a means of privately communicating orally and in real time with the attorney for the defendant or child respondent who is in the room where the child victim is testifying.
We reviewed this with the courts, and they're motions for to adopt the amendment. It's been seconded, so now the bill's before you as amended. Well, once it's been motions for favorable, it's been seconded. Okay, same here. All right, so Senator Folden would like to be added to the bill. Senator West would like to be added to the bill. Senator Waldstreicher would like to be added to the bill. Senator McKay would like to be added to the bill. Senator Smith would like to be added to the bill. Sidnor is on the bill. Charles is on the bill. Muse is on the bill. Senator James, would you like to be added on the bill as well? Everybody else on it. Yeah. All right, Senator James is on the bill. There you go. The whole committee's on the bill, except for Henson, who has an excused absence. Sure. All right. So the entire committee's jumped on. Senator Muse has a question.
Not about that bill, it's something. If we're finished with that. I noticed my bill 193, the memorial for 210 is listed as withdrawn. And that's a mistake. It shouldn't be. At least I didn't withdraw it.
I have a letter from your office.
Okay. Well, let's just hold on real quick. Let's just. All right. So now this bill is before you as amended.
I'm sorry. I thought we'd done.
The motion is for favorable with the amendments. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Senate Bill 274 passes unanimously with the amendments. Okay. Next on to Senator Muse's question and his bill.
That's out my bill, but it's really also my delegate's bill. But we've had a very large contingent. I don't want to leave.
Oh, sorry, get him off. Sorry. Okay. Yeah. I do. Yeah, let me see. Excellent. I think Senator Love has a point that we should definitely consider. I mean, the committee's decision how to move forward, but I think it's a very valid point to consider. So, Senator Love.
Thank you. I understand that 210 is a deadly highway, and I am not speaking against your bill or the raising of fines. The issue I wanted to raise for this committee is a policy question. Do we want to open the door of changing the fines on a particular road? Because we know that if we do that for one road, we will have multiple people coming in for multiple roads. Everyone will have very valid, very good reasons why they believe that this particular road deserves higher fines. So I think it's really a policy question that this body needs to decide, whether we want to look at individual roads and raise the fines for those individual roads. And yes, I get 210 is the deadliest one in the state, but after 210, there's going to be another one. That's the policy question.
Deadliest one in the nation, and I guess, you know, people do come in all the time when it's up to our discretion. If they come in and say, I want it for Baltimore, it's up to our discretion, but it's a local, in a sense, it's a local bill, even though the delegation thought that we should do it this way. So in a sense, it's a local bill. It's 210. It's on the highway, and I'm going to ask for that courtesy. We had the bill in last year, and pretty much we said we would work it out. And everything that the department asked, we worked out with them. And so I just, you know, I want to take this home and say we got it done.
So if I may, Mr. Chair, I'm like I said, I'm not commenting on 210, but we know, you know, last year, no offense, Senator Charles, last year the speed camera bill on stop signs was a local bill. It was granted local courtesy. Now this year we have 2 more jurisdictions coming in asking for that local courtesy. And yes, it is our discretion, that is our job, but once that door has been opened, you can't close it again. So that's just what I would like us to wrestle with and determine, do we want to open this door? Are we okay with it or are we not? And are we okay with just this one and then we're going to slam it shut again?
Well, because again, this bill, whatever other one came in this year, you know, this bill, whichever, this, I wish they had have said that last year because we wasted a lot of time bringing the department together with us over the interim so that we could get it in the right form to pass it this year. So it's not just a new bill that's come up. I don't know who else will come in and do it, but this is something we've been trying to do. We got, you know, for ages in a sense. I know Valderrama has had it in more than one year. So I'd like to look at something we can do. I don't want to go back and say we've done nothing on there because I got a problem there.
This has been brought up.
Yeah, yes. Oh, got him know this.
Yeah.
And in this committee?
Well, I haven't been in this room before, but in discussions, other discussions, yeah.
All right, no, so I think this is good discussion. I mean, look, it's the most deadly route in all of Maryland and 6th in the nation, I guess, but we'll get it in the nation. So we'll get, you know, I think we're going to look to move these in tandem. We'll get the data from NHTSA and SHA, or MDOT rather. You know, we'll get it done. And Senator Love used to chair the subcommittee on the ENT for transportation. So we actually, I mean, there's an expertise there, and I know that this is kind of a part of our portfolio, but it's not the main event in JPR, but it is our portfolio, and I think we do a good job. I do think there are some, you know, Senator, I got your email last night about some of the guideposts that you all use for cameras. I think it's very instructive, and I think we'll try to incorporate that into, I think there's some lessons learned that we could have here, you know. Mostly, the only things I like from the House are former members, but, you know, this is actually it was a pretty instructive document. I think we could all learn from it, so I'm going to make sure the committee has it. So I thank you for sharing that with us. Okay, so we'll hold it, and we'll reengage over the week and come up with something.
You want to just do all the withdrawals as one?
Yeah. All right, just real quick, there's a housekeeping matter. There are several withdrawn bills. You want to just rattle them off? Or?
Senate Bill 14, Senate Bill 193, Senate Bill 700, Senate Bill 786, and that's it.
All right. So the motion is for an unfavorable withdrawal. Seconded, is everyone okay? Okay, great. All right, so now we'll move on to Senate Bill 152. That's yours, Wes.
Senate Bill 152 establishes that each animal harmed in a violation of Title 10, Subtitle 6 of the Criminal Law Article, which pertains to crimes against animals, is a separate offense and must be deemed an individual victim for the purposes of the sentencing guideline stacking rule. The bill specifies that a conviction for a violation of the subtitle cannot merge with a conviction for any crime based on the act establishing the violation, and that a sentence imposed for the violation of the subtitle may be separate from and consecutive to or concurrent with a sentence for any crime based on the act establishing the violation. The bill also clarifies that specified crimes relating to animals do not apply to either hunting or fishing activities that use the most humane method reasonably available if they are completed in accordance with the state wildlife or fisheries law or regulations.
All right, there's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Okay, Senate Bill 152 passes unanimously. We're going to go to Senate Bill 421.
Senate Bill 421 expands the prohibitions under Section 10404A of the Criminal Law Article to prohibit a person from willfully destroying, damaging, defacing, or removing landscaping or part of the grounds of a cemetery. The bill also expands an existing statutory exception to the prohibitions under 10404A, which would allow for the removal of landscaping from a cemetery or burial site for the purposes of repair or replacement. Violators of this section are guilty of a misdemeanor and subject to the existing penalty of imprisonment for up to 5 years and/or a maximum fine of $10,000. The bill also extends the statute of limitation to prosecute a person for a violation of A or B of that section from its current limitation period of 1 year after the offense was committed to instead be within 3 years after local authorities, in fact, knew or reasonably should have known of the alleged violation. There's one amendment in your voting packet. That is amendment, this is Senate Bill 421. That is Amendment 763527/1. The amendment makes, turn your attention to the reprint. On page 2 of the reprint, instead of a 3-year statute of limitation after local authorities knew or reasonably should have known of the violation, it instead provides that a prosecution for a violation of A or B of 10404 may be brought at any time. It also adjusts or alters the prohibition down at line 24. Instead of landscaping, it adds the term any other part of the grounds of a cemetery. So the prohibition now would be that subject to the provisions of paragraph 2, a person may not willfully destroy, damage, deface, or remove an associated funerary object or other structure placed in a cemetery, a building, wall, fence, railing, or other work for the use, protection, or ornamentation of a cemetery, or, and here's the new language, any other part of the grounds of a cemetery.
Who's on the work group? Hold on one second.
So I just want to ask, we moved that you can seek charges on this, like it was a 3-year window from, and now there's no statute of limitations on it?
Correct. So the existing prohibition is a misdemeanor, and in general, misdemeanors in Maryland are subject to a 1-year statute of limitations. There are exceptions under the court's article. This I tried to do a count of other misdemeanors that did not have a statute of limitations in Maryland.
That's what I was going.
Not an exact number, but just in Alexa search of where the specific phrase that we use to indicate that they don't have a statute of limitations, I got about 36 hits.
Yeah, how many?
36.
And I got to ask, like, what are those? Because the only ones that I was familiar with would be like the felonies where it would be where there was no statute of limitations beyond like 7 years, as I remember,
Right.
was usually the
So actually felony Felonies are generally not subject to a statute of
No, I understand. That's
Right.
what I'm saying. Like, those were the one, like, the longest one I knew of was 7 years associated with some type of crime or something, but that all these felonies, rapes, assault, this felonious assault, the murder, all that, there was no statute of limitations. So I'm curious what other misdemeanors we have that has no statute of limitations, because
Right.
the one, and the reason I'm asking is this is not like, most of the ones that don't have a statute of limitations are usually against a person that creates some type of injury directly to that person, so that you can have those charges, like you can seek justice for that victim. This is, we're talking about, albeit not okay, but we're talking about property at a cemetery. Is that right?
Right. We're talking about.
And we're talking about a misdemeanor.
So.
Because a lot of these things could be undiscovered for a while.
Yeah, I mean, there would be things that would go undiscovered for a while, but I guess that's what I'm asking is, things going undiscovered, the 3 years starts by the date of the report.
So.
Unless they could prove exactly when it happened.
Right, so
but otherwise, it's the date of the report.
So, and actually, the way that it came in would sort of be anomalous in terms of how statutes of limitations work for crimes in Maryland. Typically, now in a civil sense, you're right. It's generally from the point of discovery. In a criminal sense, I'm really not familiar with any other criminal statute that runs from the point of when the crime was in fact discovered. Right. Now, what you do see is a commonality with the crimes that are misdemeanors that are exempt from a statute of limitations in Maryland. Those are typically crimes that do go undiscovered for quite some time. So fraud, bribery, things like that.
But the custodial or the evidentiary recovery in those is different because it's documented through some type of paper or electronic tracking device, because it is recoverable. Whereas this is, if you're talking about a funerary object that's exposed to the elements or people coming in and out over the period of years, I don't understand. Like, I agree with the bill. I just don't know that. I don't know of any such case that would warrant us changing this to a timeline that is, the statute of limitations is in perpetuity because the evidentiary value decreases. We're just like, it just seems anomalous to me that this is not something that is directly correlated to an injury of a person that was violent or it resulted in death, that there are witnesses or evidentiary value that's already been collected and safeguarded by the proper collection processes, or that is not discoverable through electronic formatting or some type of accounting or other things where it is clearly documented when the occurrences and the violations occurred. That would be my question. This is seemingly to me a whole new area of the law for that. So I guess what I'm saying is I would like to, yeah, I don't know. Sorry, everyone. Same question, okay.
Thank you. Building on what Senator Folden said, I absolutely support the bill as it came in. I am very concerned about just lifting the statute of limitations entirely. And I think about, a kid who rode their bike on purpose because they were being a brat and destroyed something. 30 years later, they can now be brought up on misdemeanor charges. How do you prove that? Obviously, it could be dismissed for lack of evidence and that sort of stuff, but I'm very hesitant about lifting the statute of limitations.
I just wanted to say when we were back talking about this, the question that's being raised was a question that I raised. So we went through and talked about a few of those, of the 36 misdemeanors that didn't have statute of limitations, because again, I didn't want to trade blazing a new trail either. But and I don't know if Jamie has the list, but it made me comfortable that we weren't blazing any new trail. But again, I had the same concern initially.
I guess this is a question for Folden. I understand where your concerns, but I'm not exactly sure in the example of the bike. Some kid with a bike who then, and in this case, kicks over a tombstone. We find out 20 years later, you still shouldn't be kicking over, and it's disrespectful to the dead and the family members and that kind of stuff. It's still a misdemeanor. We're not talking about a felony. We're not talking about, I don't understand why, well, now I'm a whole lot older and 20 years have gone by, you're still not accountable for your actions. I don't know how you wrap yourself around that, so.
So just a couple of the statutes where this came up. Bribery of a public employee, burning with intent to defraud, rehypothecation of personal securities, rehypothecation.
You've never done that?
Only every Friday.
A provision of the economic development article pertaining to false statements or reports. Let's see.
So this is my concern, is that all these things are traceable to a documented time of occurrence that I'm hearing. I don't have a problem extending it from 1 to 3 years. I don't, because of the time that people visit. I don't have a problem with that. I do have a concern about the indefinite, because those areas are provable by documentation that I heard, and this one's not. So and it would still start from the time of discovery, would it not, because of this? If you couldn't prove when it happened, it would be the time of discovery would be the,
right, under the.
so it would be 3 years from that time. So even if they didn't show up for 10 years and they noticed it's damaged, it would be,
So I would
be when
point
it
out
started.
that as it's drafted, it may be a point of contention about what is actually a local authority and who meets that definition. That's not really defined in the bill. Would it be somebody from the Public Works Department, or would it need to be law enforcement?
So, and I'll finish in this. If someone's involved, Jamie, and maybe you can answer this, counsel. Someone's involved in a misdemeanor assault, secondary assault. You know who hit you. They know. And what's your time period for that to file charges?
Just as a misdemeanor second-degree assault, I believe that's just the normal 1 year statute.
1 year and a day, right?
I think it's just 1 year.
I don't know. I thought it was 1 year and a day, but
Okay.
it's always been. But there we have that. I always worry about getting ourselves that camel's nose under the tent and opening up a new area that those are all documented with electronic tracking or discoverable things that you can prove beyond that, if it was fraud or whatever. This one's different. This one's, and I don't want, because then we're going to have, well, we did this for this, so why don't we do it for, if we want to do it for misdemeanor assault, then, I mean, why aren't we extending it for that?
So when this was introduced in the House last year, it was introduced at 5 years, but the House was not comfortable with 5 and they ended up with 3. So that's why it came in this year at 3. The argument behind it, I don't know.
Well, it came in at 3 though, but now we're going beyond the 5, which they weren't comfortable with last year. So I guess, I want to see the bill succeed. So do we want to see it succeed, or do we want to, 5? No expiration, no statute of limitations is worse than 5. Would we not just stick with 3 and then move it in that fashion? I like it when it came in at 3.
Whatever's the will of the committee is, I mean, we'll take the 3.
So then we're gonna, all right, no. So there are two major parts for this amendment. So I guess we'll just work off the regular bill. So instead of the amendment, we have not adopted the amendment anyway. So let's go back to
The only change in the amendment was that timeline?
No, it was on the grounds. Go read that.
Right, so, from, as the bill came in, it provided an additional provision that said that a person may not willfully destroy, damage, or deface or remove landscaping or part of the grounds of a cemetery. So what the amendment that you guys were just discussing also did was it struck the term landscaping, and instead the prohibition applies to any other part of the grounds of a cemetery, because that's part of a list in the prohibition. So this was made to be more of a catch-all for anything that wasn't covered in that list.
Does it change anything? It doesn't seem to me, if it's already in there, that it changes anything by not adopting the amendment.
It struck the term landscaping.
I know that,
Yeah.
but didn't you say it was captured somewhere else, or no?
No,
I'm sorry.
that was in the language of the amendment.
But I would,
The landscaping, because it's not defined anywhere else.
I'm okay with that part.
so can we just make the amendment? Strike out the landscaping and not move and strike out the part of the indefinite statute of limitations?
Yeah, I mean, that's, yeah.
Are you
So
okay with
3
that?
years and
3
just-
years,
just
strike out landscaping.
So I know that the House is going to send it over at 3 years. And in theory, they are, in theory, okay with striking landscaping and having the rest. That's in theory.
So just recapping for the record to make sure everybody's on the same page. So based on the reprint that's in front of you, we're not doing anything different than the bill as it's drafted with respect to the statute of limitations. So that will be 3 years after the local authorities in fact knew or reasonably should have known of the violation. But we will retain the change to the prohibition that the amendment was making. So it will say any other part of the grounds of a cemetery. And it'll strike out landscaping. It also makes a corresponding change for an exception.
Second.
All right.
The amendment as amended.
Yes.
We're not adopting it, we're just working off the bill, right? Just working off the bill, and all we're doing is landscaping and having.
Right.
Or any other part of the grounds of the cemetery.
So working off of the bill then, Sandy, page 2, line 24, we will be striking the word landscaping or and substituting the phrase any other. Then at line 26, we'll be striking the word landscaping. And at line 27, after the phrase burial site, we'll be inserting the phrase or other part of the grounds of a cemetery.
Move the bill as amended.
I got the comma.
I,
So on the last page, Senator, page
Hey, we got to get going here, so.
3, section
Get it
G.
downstairs.
Oh, that's statute of limitations language. That will not be incorporated.
Okay. Is everyone, now the bill before you guys amended, is everyone okay? Most for favorable, the second, is everyone okay?
Second.
All right. As amended passes unanimously. All right, we have to adjourn here now to be for an event that the Black Senators have to go to, so. All right, so we're going to join voting Now I'll see you guys on the floor.
Okay.
Okay.